I move for a favorable report to the PCS of Senate Bill 156, unfavorable to the original with a referral to rules.
Heard the motion. All in favor?
Aye.
Aye. Okay.
Opposed?
Any opposed?
Seeing none, we go to
Seeing none, we go to our next bill, which is Senate Bill 303. Representative Stevens.
PCS to be considered.
PCS to be considered.
This bill is a request for the Administrative Office of Courts and an extra provision that was requested by one of our business court judges that we thought was a good idea. We'll start with the first thing. It will clarify the clerk's adoption petitions and remove a requirement to keep a paper record, as courts are now going to digital management, and it can now be filed electronically just like everything else. It allows briefs to be filed and memoranda to be filed without a court order. And then it moves business court up to e-filings by the end of 2025. Sections 4 through 11 were some technical corrections identified by the judicial branch. Section 12 conforms 15-533H to other criminal hearings for first appearances to allow the clerk of Superior Court to review and set conditions of release if a judge is not available for an extended period of time. Apparently, we created in our budget last time a safe babies court, and this sets forth a procedure to get records, information, keep things confidential, and start setting up some rules. It allows Section 14 allows that Supreme Court to go around the state holding court in any location in the state between 2024 and 2026 to commemorate several county anniversaries. They've done that before. It's interesting if you get a chance to go see it. Section 15, it updates some involuntary commitment procedures to streamline some changes that took place April 1st, and it ensures that parties can properly access confidential information containing IVC cases and clarifies procedures for filing. There'll be e-filing IVCs. I will personally tell you that I have gotten one issue with that, and we're trying to work on it. Under current law, apparently, the respondent attorney cannot get a copy of the petition unless a court authorizes it. And the the respondent doesn't get a copy of the petition. So now the respondent's going to be able to get the petition, but he can't show it to his client. And that bothers me. I think the intent from discussing this with AOC is to protect the identity of the petitioner so that the person who's being involuntarily committed doesn't plan some kind of revenge or whatever. But I think there should be some sharing of information. So we're working with the State Bar and AOC to see if we can make that correction to make sure the attorney can do sufficient legal representation. But this is as they have requested it at this point. It does open it up for at least the attorney to see what's alleged so they can defend them. But we've got to be concerned about how the attorney communicates with his client. Section 19 is law enforcement qualifications for magistrate nomination. Currently, in order for a law enforcement officer to be a magistrate, he must have at least a 2-year degree and experience. Now, individuals with 8 years of experience as a sworn law enforcement officer will be eligible to be a magistrate, and it assists recruitment of magistrates in hard-to-fill roles that benefit from law enforcement experience. 20 through 23 are some changes to the clerk's bond requirements, to repeal the clerk bond requirement by striking reference to the requirements that we took it away the last session, but we didn't get it all. Section 24, we now have more than 20 judicial districts, and the J20 is now a district due to the judicial renumbering. So the DMV plate issued for J20 is actually going to the director, and now we've allowed them to authorize up to 99 positions for judicial officers. The last part of the bill has to do with out-of-state attorneys coming into the state to practice. We are attempting to ensure that somebody's not just coming here all the time and practicing law, and we've seen more and more of that. So if you reside in another state, you have to fill out a form to request the Pro Hoc Vitae. There are certain other things that are going to be required of them. They have to give their date of admission to the foreign state, proof of good standing, more identity about the client that they're seeking to represent, and a statement that they will report any taxable income to North Carolina. It removes the requirement that they demonstrate the state in which it removes the requirement that the state in which they are admitted grants pro hoc vice to North Carolina. Okay, so their state doesn't have to accept us, but we will still accept them. It establishes that it's clear that North Carolina attorneys are the only ones who can advertise. So we just make it extremely clear that if you're an out-of-state attorney, you can't advertise here. And if you've been there, if you've been here at least 3 times per year without becoming a North Carolina attorney, then you would be prohibited from being admitted pro hoc vice. It also allows the state bar to discipline those out-of-state attorneys under the same regulations that we all answer to. Be happy to stand for any questions, maybe.
Do we have any questions? President Moran?
Thank you, and thank you for the summary. I really appreciate what you did with the IBC and information going to the attorney and respondent. Thanks for that. My question is about, or a couple of questions about Safe Babies Court. And I'm wondering, in this provision, are we divesting the local district court, juvenile court judge of jurisdiction by having AOC designate certain cases to go to Safe Babies Court?
I'd ask you to call on Joseph Kaiser.
Mr. Kaiser? Would you state your name and position, please?
Good morning. Thank you for the question, Representative Maury. So I'm not aware of any divestiture, right? It's Safe Babies Court is what we're calling the change. It's really a program, right, that allows the district court judge that's already hearing that matter to refer them to. So that's what 535B sets out, that we'll set up the criteria for the referral. But we see it more like other treatment courts, like a drug treatment court or something there, that's not divesting that judge who has the case. It's more of a program to help them reach better outcomes, right? This sets up a transparent process for them to meet and really provide wraparound services to that family that's in the abuse, neglect, dependency space, only for children age 0 to 3.
Thank you. Follow up?
Yes, ma'am. Follow up.
Thank you. I'm somewhat concerned about some of the language about the disclosure of records, non-disclosure of records, that in section, page 8, line 12 to 20, we're talking about the AOC director, and the AOC director's sole discretion may authorize the disclosure or redisclosure of de-identified Safe Babies Court records with no court order, and then motion for disclosure. It gives the AOC director a lot of, I guess, authority and discretion, not the local juvenile district court judge, for copies of what are pretty sensitive confidential files about juvenile abuse and neglect dependency cases. So I'm just wondering how the coordination of an AOC director involved into a local district court, juvenile court case, providing more services, and yet the AOC director has total discretion and authority over these records. Maybe you can explain the process a little bit more.
Yes, thank you, Representative. Joseph Kaiser with the Administrative Office of the Courts. Thank you for that question. So D is written to provide that authority to the AOC director. Throughout Chapter 7A, that's a theme of how AOC's administration of court programs is established, that the AOC director shall or may have some authority, right? And then that's generally executed through the administration, in this case, of this Safe Babies Court State Advisory Committee, the Safe Babies Court State Director, who are appointed through the Administrative Office of the Courts. So that's the structural setup for really what is the director to appoint, right? Folks like myself or others within the court system to further those duties. So that's why it's written to, what appears to give that to the director is really to the agency. The records piece is only for de-identified records. So that's setting up, right, that those confidential child welfare records, my understanding, are de-identified in ways that remove, right, a lot of the PPI or other information that allow them to determine what child or what case that is. So that's my reading of de-identified, but Susan Seitz or other staff may have more information on that.
Call on staff, Ms. Seitz.
Yes, Representative Morey, just to clarify, record in this statute is the stuff that is not part of the juvenile court file. So we're not releasing the juvenile. If you look at on page 7 at the definition of record, it's only the information that is not part of the juvenile court file. So we're not releasing any of the court file by that. It's the any additional information.
Follow up. What would not be a part of the court file?
I'm not sure. That would probably be a better question for Mr. Kaiser.
If I may, I believe Amy told me that it's program files. It's things within the administrative office of the courts for record keeping purposes, but nothing that happens in the court takes into there. It's just, was it in there? Was it not? And who they can disclose that to. If you were de-identified, you may need some information. If somebody knew an investigation was going on, you may need AOC to say, no, there was no case.
And just one other question, please. And I'm sorry.
Final follow-up.
Thank you. The coordinators, the Safe Baby coordinators, who are they reporting to? Are they staying within the juvenile court in that district? Are they reporting to the AOC director?
Yes, ma'am. Thank you. Joseph Kaiser with the Administrative Office of the Courts. Thank you, Representative Morey. That's a great question because we spent a lot of time talking about that. And the coordinators right now, they work for the Chief District Court Judge in the pilot district. So New Hanover is one of our pilots. That's Judge Corpening. So we had, again, as we're establishing this, thought of both approaches and settled on right now these coordinators like court coordinators and judicial support staff across the state report to the judge or the Chief District Court Judge.
Thank you. Appreciate that. I just think some of this language is confusing. Just like that, nowhere in here does it say they report to the Chief District Court Judge, that it looks like everything is directed by Raleigh at the AOC level, not the District Court, Juvenile Court level, that they ask for extra help with these safe baby courts, trauma-informed courts, which is great if it helps. We know we need a lot more services to help kids in foster care and help parents get the services they need to reunify a family. I'm just worried about some of this language. I think still needs to be worked on and clarified so there is a clear demarcation of who has what responsibility. And other than that, thank you for answering.
Yes, ma'am. If I may, very briefly, Joseph Kaiser with the Administrative Office of the Courts. Thank you, Representative. We'd really appreciate any other feedback that you have on it. It is new law, right? And the State Advisory Committee for Safe Babies Court includes DHHS, DSS, IDS, AOC, GAL, right? All our acronyms in the JPS space. And so this was sent to that committee as well and presented to them at their most recent meeting. I presented it, and so we'll get that feedback to those folks and continue that because we know it's new and appreciate your interest in it. Sure.
Any further questions? Representative Budd?
Yes, I like this initiative that focuses on children and trying to find some permanency for them earlier rather than later in the process of foster care. But I did have one question, kind of echoing Representative Morey. Well, I think this is a great initiative. I think perhaps fleshing it out will be more useful for those who are going to be underneath this statute and working within it. But my question for you had to do with respect to sibling groups. Was there any discussion in the formulation of this concept of how to keep sibling groups together? Because oftentimes in foster care, you will have new babies, but you will also have siblings and half siblings that are sometimes up to 10 years older. And this seems to be focused only on babies and very young children. But studies have shown trying to keep sibling groups together can have a very positive impact down the line for their growth and maturity.
Thank you, Representative. It's Joseph Kaiser with the Administrative Office of the Courts. Thank you for that as well. A couple of points that it is still being a pilot phase at this point. And so a lot of those details and a lot of that is still taking that kind of feedback and making sure that we get it to the State Advisory Committee. So it's only in 2 district court districts right now. So a lot of that's coming in. Certainly that's the vision, one of the primary visions for Safe Babies Court, right, is that generational trauma you're describing of a 3 or a 4-year-old had a TPR and now maybe the parents are back in the system, right, with a new child or maybe one that's in foster care and not termination of parental rights yet. So as addressing that is really the core of the vision, right, not just for one child, but for so many where we see so many others. In terms of whether all the children come in, if one parent does a 0 to 3, I believe is something the State Advisory Committee talked about a lot. That's not set forth clearly here for that reason, right, for those courts to be able to see if through the pilot project if they'll bring them in formally or if it stays on that 0 to 3 focus. But really that services and improving that is a benefit for, of course, their whole family.
Representative Butler, do you have a question?
Thank you, Mr. Chairman. Just quickly, and again, this is not in my bailiwick, so I apologize if this is a question that's everybody else knows the answers to. This says that participation in the court will be determined by criteria established by AOC, and I wondered if that's a typical process. And you mentioned drug treatment court, for example. Is AOC responsible for determining the criteria established for drug treatment court?
Thank you for the question, Representative Butler. So Joseph Kaiser with the Administrative Office of the Courts. Drug treatment courts are set up in the JMARC statutes, the Judicially Managed Accountability and Recovery Courts now. That statute sets out a lot of sort of dual authority, where AOC is to establish the State Advisory Committee on JMARCs, which is to recommend criteria and best practices. And then each JMARC is also authorized with a lot of authority and a lot of requirements of what they're to report and do. So there's a little bit of a hybrid authority within the drug treatment courts. I think that's where you'll see this also, of course, land through that same similar process of the state programs. AOC sets up that broad criteria of limitations and requirements. Certainly there'll probably be some more authority as well at the local level, right, for who the judge, as we were just discussing, will refer to the program.
And just a quick follow-up.
Follow-up.
And so I guess just not to belabor the point, but would you say that the way AOC is vested with the responsibility of determining these criteria is a departure from the way it acts in other specific types of courts? It feels a little that authority vests there a little more strongly perhaps in other places. It seems more, as my colleague said, that decisions are being made from Raleigh rather than the local jurisdiction where our judges and our caseworkers and our social workers and our guardians ad litem might know best.
Representative Stevens will answer that.
Okay.
Thank you, and that's sort of where I wanted to step in a while ago anyway. I'm taking off my judiciary hat, and I'll put on my administrative procedures hat. Here's what we tend to do. We established this court in the budget last year. Now we're looking at the kinds of authority they may need, and then they are supposed to take that authority, create the rules that go along with it, and that's supposed to go back through Rules Review Commission. But they can't even do that until we give them some kind of authority. And that's sort of what we're doing here. I mean, I'm happy to revisit with you and see what happens with these as they experiment. DSS does this a lot. The court system does. That's how they get local rules, how they get local enforcement of things. That's how when we create a drug court, it'll be different. My area wants to create a alternative recovery court, and they'll be deciding, mental health cases, drug cases, alcohol cases, things that will come into play there. So they'll need some freedom to set up rules. We just simply give them the authority to do it, and then they set up rules. Rules review is supposed to say, have you exceeded your authority? So that's what we'll be looking at as hopefully DHS takes this through rules review. Certainly.
And final thought, Mr. Chairman, I want to thank you for this, because anything we can do to, shorten shorten life in a foster home is obviously a better approach. And I did some reading on this, and they're having some success with some of these other programs across the country. I just want us to be able to replicate it and to put it in the hands. I'm very close to Judge Corpening and his group, and they are doing incredible work in New Hanover County, as I'm sure you're aware. And we just want to make sure that the people with boots on the ground are doing the job they know how to do, rather than us folks up here in Raleigh. But thank you for it.
Any further questions? Representative Smith?
I just one question for the sponsor. There was a question about the rights of the IVC respondent. Is that something we're going to try to fix in rules or on the floor with some different wording, or is it good? Do you like it the way it is now?
I'm consulting with the bar and AOC, and luckily have clerks here today. If we need a change, we'll do that between now and rules. And that'll be the only change I'm anticipating, is that we decide how much information can be shared with the respondent. At least now the respondent's attorney can see what they're dealing with, because under current law, they can't even see. So at least they can see, but let's weigh that against their duty to represent their client and to maintain that confidentiality. So yes, if there's a change, I will make it before rules, and we'll do that in rules.
Thank you. For a motion when appropriate, Mr. Chairman.
Yes, sir. Go ahead.
I move for a favorable report to the PCS to Senate Bill 303, unfavorable to the original, and a referral to Rules, Calendar, Operations of the House.
You've heard the motion. All in favor?
Aye.
Aye. All opposed? Motion carries. Our final bill today is Senate Bill 124. Representative Stevens.
Thank you. PCS?
PCS before the committee.
Okay. I'm sorry. I have my copy too, but I'll go ahead and get it. Yours. This is a bill that the House has passed for 2 different sessions, and then the Senate would never take it up. We're now told the Senate's willing to take it up, so we're just going to send it back to them and see. What this attempts to go to is predatory persons who go out when there's storm damage or tornado damage or whatever, and get the people to sign an immediate contract that again will encumber their house, not knowing whether insurance will cover it or not. So what this says is, if you are not a licensed contractor, that you cannot accept the money until and get a contract signed until, was it 3 days or 5 days after you find out whether insurance covers it or not. And you can get some money for emergency repair, and I think emergency repair is even defined. So I was waiting to see if because it was Dean Arp's bill several times, and so I think I'll have Dean present it on the floor. But yeah, it just enough to make sure the house doesn't fall in, but not to get all the other roofing stuff done. If the person who's not a contractor refuses to do these things, refuses to revoke any kind of contract, or even gets them to sign a contract or gets payment, then it would be a class 1 misdemeanor. And then again, there could be additional, it doesn't negate any other charges, such as obtaining property by false pretenses, or, saying you're going to do the work and never coming back and doing it. So it's just trying to get into that one little, perhaps, niche that you're holding people responsible because they signed a contract when they thought they had the money, and they may not have the money, and so protecting them from unscrupulous persons.
Representative Butler.
Yeah, we see this, of course, down in New Hanover County, plenty. I had a quick question. I'm not sure, and maybe I'm reading it wrong, but it appears that this is like a right of rescission. Maybe staff can tell me. It looks like the consumer would have the right to cancel the contract once they realize their insurance claim has been denied. But I'm just wondering what happens when that thing's already been partially re-roofed, or if we're in the middle of it. Is that?
I'll defer to staff on that one, but I think that's where the penalty comes in.
What the bill does say is it does allow them to sign the contract.
Yeah.
But it provides a right of cancellation for up to 5 days after the insurance has been denied. It prohibits them from collecting any money or performing any work except emergency work prior to that 5-day period after denial. Implied in that is if it's approved, the contract's good to go. But basically, they cannot do anything until that insurance denial or approval has occurred, except for emergency work.
Right, good, thank you.
Representative Bud?
Thank you. I really like this bill. I do construction litigation and run into this all too often. Wondering whether or not it would be worth placing a provision in there that any of these contracts entered into by law would be considered void, such that the civil remedy is much less expensive for the consumer, since we're looking to protect the consumers in this. Oftentimes, if lawyers are involved on the civil side in any way, the criminal system, law enforcement, doesn't typically get involved because they're overworked and under-resourced. So they simply say, let your civil attorney handle it. So while this provides a violation, a misdemeanor violation, which is not a bad idea, a civil remedy would provide immediate relief to the consumer.
Any comment?
Any
I think
comment?
this is a civil remedy, I don't know, but.
I will say that civil law is not my area of law. I believe the intent of this, and I don't want to speak for the advocates for it, but I believe the intent is to provide a method for the people to actually be arrested and charged with a crime. I don't know that this is intended to contemplate all those civil issues or not. But that being said, if that's something you're interested in, we can try to figure that out. I just don't know off the top of my head how all that works.
We have a representative from the Department of Insurance. Are they here? They could speak to this? Would you like to speak on it?
John.
I am not a representative of the Department of Insurance. I'm John Harden. I represent the Insurance Federation of North Carolina, which is the state trade of most of the property and casualty insurance companies that y'all know very well. Let me start by saying this, as Representative Budd and Representative Butler, and I know Representative Miller, you probably encountered this on the coast as well. It is a humongous problem. Representative Budd, to directly answer your question, this is what we believe a first step in the right direction. And as Representative Stevens alluded to, we have had some challenges on the Senate side getting this done. We feel very comfortable with the current provisions in the bill that we can get this piece across the finish line this year and then work collectively with you all and the Senate to add some additional guardrails and regulations as we move forward. So my recommendation, for what it's worth, is that we move this piece forward and then continue to work with all the stakeholders to add some more teeth to this in future dates. But this is a huge step in the right direction for the carriers, for the agents, and for homeowners. So, thank you.
Representative Moore?
And thank you. Just a question from the summary and looking at the bill in section 7 toward the bottom, it says there's an exception when performed by a licensed general contractor. Are we distinguishing licensed contractors or those subcontract versus the non-licensed?
Staff?
Yes,
Staff, good answer.
yes, we are distinguished.
Yes, if they are a licensed general contractor, they are not subject to this requirement.
Thank you. And just to follow up, or a person that subcontracts under a licensed contractor. So they're exempted from any of this. Is that right?
If they are a subcontractor working under the supervision of a licensed contractor, they are exempted from this particular penalty, yes.
Just general follow-up. If this is such a problem, and it sounds like it is, why are we exempting licensed contractors? I mean, it sounds like everyone should follow under this restriction in law.
I'll fall back on John Harden's comments. We get what we can right now and come back and get more later. That's how it works.
And I would just add to that, John Harden, Insurance Federation of North Carolina, Representative Maury, the people we've identified as the real problems are not general contractors licensed in the state or even subcontractors. These tend to be, and y'all have all had family members or friends, they tend to be people who come in from out of state after a storm and intentionally prey on entire neighborhoods. And so what we've attempted to do is really narrow the scope to get those folks in this. If we see over time that there are subcontractors working under a licensed general contractor, we're happy to widen the scope. But right now we feel pretty confident that this will target the real problems.
Representative Butler.
Yeah, that's a good point. And I'm wondering how do we educate the consumer about their rights under this? Because what happens is a storm comes, everybody panics, these vermin swarm in and start roofing, and the consumer doesn't really know, what their rights and remedies are. I think maybe some sort of educational push on this, however that works.
Mr. Harden.
John Harden Insurance Federation. I can tell you that my clients will endeavor to educate their insureds and homeowners.
Let's put an insert in their bill, shall we?
I'm going to leave it up to companies as to how they want to do this, but I am confident when I tell you that they will absolutely want to spend resources to educate folks on
Good
this.
deal.
Representative Bud.
Thank you. Just a quick follow-up. And I do understand the concept of this is a great starting point and we should take it and go with it. But I want to reiterate, there's a gaping hole right in the middle, as Representative Butler put in, when a storm comes and the vermin swarm the neighborhoods. While there are going to be education points to the consumers, there's no language in the statute that gives a consumer the ability to understand that they can terminate that contract at will. It's void. They don't have to comply with it. And so you've got to keep in mind that the folks that are preying on these consumers, they're going to be the savvy ones who come in and say, no, you can't get out from underneath this contract. So unless there is language in the contract that's required that says this is subject to a 5-day cancellation, if your insurance company denies it, my concern is that, again, we've left a hole where we're really trying to protect the consumers. So for what it's worth, as we move forward on this bill, I think that needs to be part of the conversation.
I'm going to go back to the very initial comments I made. This is our third session trying to get this bill through, and we have some agreement on what we can do. I'm not disagreeing with any of you that we need to do more, but let's do what we can now and continue to move forward. Certainly happy to work with you, and I know Representative Arp is. I mean, as a person who works in the kind of stuff he does, he's more than happy to do it, but we got to get what we can get.
Representative Smith.
I'm out of my lane of expertise too, so I'm going to ask some of the brains in here. Licensed general contractor, I'm sure that's defined somewhere. We are talking about a licensed in North Carolina general contractor. Somebody can't come in from out of state, licensed somewhere else, and be exempt from this. Is that right?
Staff.
I believe that's correct, and I'll double check that, and if it's not, I'll let you know so we can try to fix that down the road, but.
Follow up. Yeah, I think that's important because it is the ones that come from out of state, and they may claim, well, I'm licensed in another state, but they're not in that state working because they're not that good probably. And if nobody else wants to, somebody else can, but I'd be glad to make a motion when appropriate unless somebody else wants.
You can go ahead with that motion, sir.
Well, you're more of an expert than she is what she said.
Not a lot of things. Mr. Chair, I move for a favorable report to the PCS of Senate Bill 124 that the House made better, unfavorable to the original with a referral to rules.
Yes, rules.
Referral to rules.
Heard the motion. All in favor? All opposed? Motion carries. Nothing else coming before the committee? Anybody got any questions? We're adjourned. Thank you.
So, you need to send the PCS.